My name is Nate the Lawyer. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel. First, let's go over some common objections. Do you mind, John? Let's go over some common objections. Calls for speculation. This one is the question. Ask the witness to guess an answer rather than rely on the facts. What do you think about this objection?
I mean, I think that it's
pretty simple.
Well, I mean, straightforward.
Yeah.
It's often misused, but the way that it's used most frequently is when you're asking somebody about somebody else's thoughts, basically.
Yes. Yeah, exactly.
I mean, Mr. Depp thought of enough about this article to have a 3-week trial in the UK, correct?
Objection. Calls for speculation about what Mr. Depp thought.
I'll sustain the objection.
All right, so asked and answered is pretty simple, right? The same attorney asked the same question multiple times. And usually you'll find that on cross and direct, because on cross, they're trying to box you in, so they may ask you the same question multiple times, either try to get a different answer, but generally it's asked and answered is you're asking the same question and expecting a different result. I mean, you're asking the same question twice, and it's already been answered. Pretty straightforward.
Is it your testimony that you didn't know that you were named specifically and the terms of your compensation and your benefits were in every single one of Mr. Depp's contracts?
Objection asked and answered several times, Your Honor.
Next, lack of foundation. Lack of foundation, the question relates to a matter in which the witness's personal knowledge has not been established. John, do you want to explain this one real quick?
Yeah, so basically it's before you can, ask somebody, what did you see? You have to, at the crime scene, you have to establish that the person was actually there first. So, that's the easiest example of it, but obviously it can come in different forms.
Yes.
Thank you. You were asked about a knife. You were shown Plaintiff's Exhibit 92 and a knife that's, I think, is till death. What is your understanding of the significance of that knife and that phrase as it related to Amber Heard?
Objection, Your Honor, no foundation.
He showed it in cross-examination. I'm able to ask about it and what her understanding was. He cut her off when she was trying to talk. I'm just letting her go back in.
Her understanding of a knife?
Next one is leading. Now, this one gets everybody so confused, because I know a lot of you this is the first time you're being introduced to this. I'm just going to make this as simple as possible. If the form of the question asks for a yes or no answer, generally it's going to be considered leading. That's not the case in all occasions, but because I understand you guys aren't going to understand the nuances here, if I ask you, if a question is asked and the witness can just say yes or no to answer the question, you'll generally consider that lead. Do you think that's the easiest way to simplify this?
I think that's the easiest way to simplify it, and there are a lot of judges that don't get that nuance either. I mean, I think Nick Rekieta went on repeatedly on, a yes or no question doesn't necessarily make it leading, but a lot of judges basically go with that rule of thumb anyway. So that's what you got.
Yeah. So that's what we're going to do. So we'll see.
This is an email from Mr. Depp to David Kipper. Your understanding was that was his doctor, correct?
Correct.
Okay. And then I'm going to draw your attention to the last part of this, and this is on 3/19/2015. Thank you for everything. I got to figure out how to do this. I'm missing the controls on this. Thank you for everything. I've chopped off my left middle finger as a reminder that I should, thank you, Your Honor, that I should never cut off my finger again. Do you see that?
Yes, I do.
Okay, so that's Mr. Depp admitting that to Dr. Kipper in 3/19/2015.
Objection, leading.
Okay.
I'll sustain the objection.
This was another example. Compound question. Essentially, that's two questions in one. So it's really two facts that you're asking. I like to consider it really, you're asking about two separate facts, but it's really multiple questions in one. And generally, lawyers are listening for that and. As soon as you hear and, blah, 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 then you're trying to see if they're asking you a compound question, right? What do you guys think? Good with that one?
Yeah, basically. If you can answer the question, but you don't know which piece, if you have two clauses and you don't know which piece they're responding to, then it's not a fair question.
Like, did you go to the restaurant and eat steak? And the person says yes. You don't know if they're saying yes, they went to the restaurant, and they might not have ordered steak. They might have eaten steak and never gone to the restaurant. They sat at home doing it. Or they might be saying yes, they did both. And that's so the problem is that the information we're going to get from them is very ambiguous. So even after they answer, we still don't know. And that's why a compound question is very poor. One funny thing that Elaine did, though, was like, there was a question that Johnny's team asked, something like, what's the difference between this and that? And which is really, that's not, and she goes, objection compound, because she heard the word and. Right.
Yeah.
She heard the word and. She's like, oh, you want to know the difference between this and that? He said and. He said and. Objection compound. And like everyone's like sort of looking at her like, what? What?
I knew she would understand.
And when approximately did you start confiding in your mom about your issues with Mr. Depp and physical abuse?
Objection compound.
I sustain as a compound.
The next objection that you're going to hear is irrelevant or immaterial. The question is not about the issue at trial. You'll hear this a lot. It's just the questions are relevant, or even the answers are relevant. This is a pretty straightforward objection.
So you flew out of that airport. Did you have a stop anywhere before you went back to LA?
Objection relevance.
Non-responsive, that means I asked the witness a question and witness is essentially asking some other question. They're not responding to the question I asked, right? Very simple.
Did there come a time that there was a family engagement gathering?
Well, we celebrated Thanksgiving out in London. The kids were there. There was a stint of sobriety following how sick he got on set with Paul Bettany after one of his drug binges, and he kind of just came alive again. He even played a prank on me about having relapsed when he hadn't relapsed. I started to kind of feel that with the kids being around. I did think that maybe this was it. We were on a good path, meaning to sobriety, that this was it. And our life was peaceful for a minute. It went back to being wonderful. There were these moments that just felt so wonderful.
Objection, Your Honor, non-responsive.
All right. I'll just sustain the objection.
Okay.
Hearsay. Hearsay is something that's going to be a little more technical for everybody, but hearsay is an out-of-court statement. The truth of the matter asserted. However, there are several exceptions to hearsay. We can't go into a real hearsay discussion because hearsay takes a lot quicker than a 5-minute explanation or a 6-second explanation. But I'm going to do the best I can. The first thing is hearsay is essentially someone else said something, right? If you're saying someone else said something, you're looking at hearsay. That's essentially what we're talking about. Here's an example. Lawyer asked the question, what was the weather outside on the day in question, right? The witness says, John told me it was raining. Your bell should be ringing. Hearsay, right? Objection, hearsay. And that's what it would be. Why is it hearsay? Because the witness doesn't know if it was raining outside. All that he knows is that John told him. And if you guys think about it, how reliable is that? Because how do we know John knows it was raining outside, right? What if John heard it from somebody else? The reliability of the statement is so weak because he has no personal knowledge of it. And John, who, if we wanted to find out if it was really raining or not outside, we would have to bring John in. So that's kind of classic hearsay. Now, that changes when we change the question. So why didn't you go outside? Question is different. Before, the question is, what was the weather outside on the day in question? Now it's, why didn't you go outside? And the person says the same thing. John told me it was raining. Objection, hearsay. Well, this wouldn't really be hearsay because it doesn't matter whether it was raining outside. We're asking, why didn't he go outside, right? And he's saying, well, because somebody told me something. So this is not for the truth of the matter asserted, whether it was raining or not, but how John reacted to the statement. So it was about his state of mind, how it changed his state of mind. The witness here doesn't really know if it's raining outside, but he changed his actions. He did something different because he heard the information. So that's why this would technically not be hearsay. We're not offering it to prove it's raining outside.
Yeah.
No, this wouldn't be hearsay because it's not being offered the truth. It's being offered for state of mind.
It's just not hearsay. The bar's really stickler on that one.
So hopefully you guys now understand hearsay because there's a lot of hearsay exceptions. But remember, now one thing about hearsay that even lawyers miss is that there's a witness declarant issue with hearsay, and and for some reason attorneys miss this a lot. But the witness on the stand, if the witness has said a statement an out-of-court statement, that too is hearsay. But there are 3 exceptions where if the witness's credibility has been attacked, or if so things like where the door is opened, where you can bring in that same witnesses. So in this instance, if Amber Heard says, yeah, 2 days ago I said X, that's also hearsay and could lead to an objection. So understand, it's not only what other people said outside, but also what you said outside could be, and with limited exceptions. So there are some exceptions for even in the Amber Heard, and we'll see that play out. But I want to make sure if the witness says I said this outside of court, that's also hearsay.
And then finally, Amber Heard wrote an email talking about how distressed and heartbroken she was.
Objection, hearsay.
I mean, I don't agree.
I know. Sustained. I'll sustain the objection. Next question.
All right.
You didn't know what could cause damage to Mr. Depp's hand while you were there on March 8th, correct?
Dr. Kipper told me he'd sustained an injury on one of his fingers.
Objection, hearsay.
Wait, you asked the question. Next question.
Okay, he said he sustained an injury to his finger.
Yes.
But you don't know what caused the injury to his finger.
One of his fingers.
So that's a short list of some of the most common objections. If you like this video, don't forget to like, share, subscribe, do all that great YouTube stuff. And my name is Nate the Lawyer, and I'm going to see you next time. Peace.
You didn't know what could cause damage to Mr. Depp's hand while you were there on March 8th, correct?
Dr. Kipper told me he'd sustained an injury on one of his fingers.
Objection, hearsay.
Wait, you asked the question.